Thank you for joining us on our TRIIPSS webinar, Federal Proposals Taxing Private Corporations Update, Overview, Concerns, Cautions, and Opportunities. To qualify for CE credits, each attendee must access this session from their own computer. You must participate in the entire webinar to be eligible for CE credits. CE credits will be emailed within 2 to 4 weeks. Now we'll pass over to Peter Wouters, Director of Tax Retirement and Estate Planning Services, Wealth. Go ahead, Peter.
Thanks, Adrian. The federal proposals released in July of 2017 were the most dramatic changes to the Income Tax Act affecting Canadian-controlled private corporations in 45 years. They triggered thousands of written responses from across the country and across dozens of organizations representing the interests of small business. This session provides an overview of the proposals and their updates, as well as concerns, cautions, and opportunities for business clients and their advisors. Attendees will gain a clear understanding of the ramifications of the proposals through a series of case studies. The session will also cover updates and changes to the original proposals and some next steps for practitioners and their clients. Now, there have been a lot of press releases, newspaper articles, debate, and changes since the original proposals were released quietly in mid-July 2017. The responses were not so quiet. These proposals created confusion and even more complexity than the proposals already contained. I'm going to go over the proposals and issues from the beginning to ensure that we are all on the same page, and because some of the proposals that have been withdrawn may come back in some form or other. They weren't, in some cases, permanent proposals. Over 21,000 submissions made the October 2nd, 2017 cutoff date, commenting on the July 2017 tax proposals, the majority of which we can safely say were not in favor of the proposals. A number of these were not short either. For example, the Canadian Bar Association made a joint presentation with the Chartered Professional Accountant submission, and it was over 150 pages long. So 21,000 submissions, and some of them were quite lengthy. When we look at the proposals and look at it from an overview perspective, the proposals will affect almost all business owners now and in the future, not just those in the top marginal tax brackets. The changes will impact many well-accepted tax and estate planning strategies. They are not tax loopholes. And there can be punitive tax multiplier effects on each tax change that can apply over a business owner's lifetime, including situations beyond the owner's control, such as illness or death. Some proposals will impact planning that's already in place, resulting in significant professional costs to review and comply. The Canada Revenue Agency is being provided with broad discretion in the application of the rules in terms of defining or interpreting what is meant by arm's length, reasonable, one of the main purposes. And that whole term reasonableness has created a lot of uncertainty and a lot of angst. It increases tax uncertainty and potential audit and tax litigation concerns. The reasonableness test will be comprised of an assessment of the contribution of labor, capital, risk assumed, and total remuneration. And the concerns exist that the details of reasonableness will be prescriptive, a checklist, yes or no. Well, what happens if an issue isn't even on the list? How will that be adjudicated? According to a number of lawyers and both the current and former Chief Justice of the Tax Court of Canada, there's just too much subjectivity, they're too vague, and they arguably can be applied on an inconsistent or unfair basis in the assessment of reasonableness. The other concern is the dramatic increase in costs associated with being compliant with these proposals. These two Chief Justices felt that it would lead to more appeals by taxpayers going to court to settle the issue. So expect increased litigation here. Because if people own shares, they have a legal right to a dividend. But the proposed tax policy appears to ignore that, preferring to apply punitive income taxes and denying the refundable dividend tax on hand in a number of situations. So reasonableness. When applied, what will happen to estate freezes and family trust? The dividend paid perhaps to an adult child who hasn't provided any capital or services. What about dividends that are paid to a parent owning free shares? Could they be caught? A wasting freeze. How much of past service will count towards a test of reasonableness? How much will be excluded? And if a taxpayer owns a holding company, what is a reasonable level of dividends to pay out of that company? And what happens if a shareholder took time off work due to an illness to raise children, could those be caught by the new tax and split income rules? What about business succession? Parents selling their children. If the shares are subject to the tax and split income rules, then the full capital gain may be taxed as a non-eligible dividend instead of a potentially tax-free capital gain under the tax exemption amounts. What about the multiplication of the lifetime capital gains exemption? Is that now gone? Would it be retroactive? When does it start? And how will it actually apply? The consultation paper addresses three main areas of tax planning using private corporations. 1, income splitting with adult family members. 2, the tax treatment of investment income arising from active business income. And 3, converting corporate income into capital gains rather than salary or dividends. Let's look at tax and split income. It will now extend to the tax and split income rules will now extend the current kiddie tax to adult family members and will include other types of income, including gains realized on property, the income from which would be split income. Example, shares, and would affect compounding income on split income. So if a person were to actually reinvest income that was subject to the new rules, the income on that would also be caught and taxed at the maximum bracket. It would apply with the shareholders under the age of 25. It may impact realized income on reinvested distributions by the recipient child. It is not good news for pure investments, and it may be avoided by cash value life insurance held for an extended period of time. But again, a big caution here, watch the primary purpose of the insurance. That reasonableness test applies where split income is earned by an adult child with stricter rules for those ages 18 to 24. And those new rules were proposed to apply in 2018. In those situations, the lifetime capital gains exemption would be disallowed or limited in a number of different situations for dispositions after the end of 2017. A share sale would not be treated as a capital gain. It would be changed to a dividend taxed at the highest rate. There was the potential that the multiplier effect of the capital gains exemption would be lost if two spouses jointly owned a business. They might have to share that capital gains exemption. And special rules will allow the exemption to be used on the crystallization or actual realization of a capital gain by affected individuals and trusts in 2018 to shelter gains accruing before that time. But that, of course, would be very expensive. And the use of personal tax credits would be denied except for dividend and foreign tax credits. Now, the Income Tax Act of Canada currently provides an exemption for all individual Canadian residents on the first $836,000 of capital gains realized on the disposition of qualified small business corporation shares as of 2017, and the first $1 million of capital gains realized on the disposition of qualified farm and fishing property. The proposals eliminate the lifetime capital gains exemption on gains on the disposition of property in three situations. 1, that accrued before the taxation year in which the individual turns age 18. 2, if the income on the appreciated property was subject to the tax on split income. Or 3, that accrued while the property was held by a trust except a spousal or common law partner trust or certain trusts established to hold shares for employees. The federal proposals would restrict a shareholder's ability to claim the lifetime capital gains exemption on many family businesses who have implemented common estate planning strategies and transactions. And a question also arises as to the valuation of property where only part of the ownership period is during that now denial period. Is there potential opportunity? Yes. And the potential opportunity is to explore how life insurance may be used to replace the value or pay the tax under these revised rules. Let's look at a couple of examples. In this first example, I'm going to look at a gender-biased outcome of the proposals as they were put out in July of 2017. Bill and Janice start up a retail business in 2008 as equal shareholders. Janice is active in the business until 2013 when she leaves to raise their baby. Janice receives no salary. The plan, though, is to pay her dividends because she's an equal shareholder of the business. The proposed rules would tax those dividends at the top tax rate, even if Bill is in a lower tax bracket, even if Bill would be in a lower tax bracket if he took out all the income himself and paid Janice nothing. Also, Janice would lose access to the capital gains exemption on the subsequent sale of the business, because all of this would now fall under the new passive asset definition. In example 2, we have Jim and Rita, equal shareholders in a farming corporation. The plan is to retire and have the son take over the business. The son's been active in that business now for a number of years. The daughter works in the city. But to have some type of estate equalization between the two children, Jim and Rita undergo an estate freeze with the help of a lawyer, an accountant, and a financial advisor, and take back preference shares with a fair market value of $1.5 million. Their plan is to pass those shares on to their daughter upon death to equalize the estate rather than use a wasting freeze and perhaps leave the daughter with very, very little money. Those preference shares have a 4% dividend rate. That would kick out about $60,000 per year in dividend income for Jim and Rita to supplement their retirement. The Canada Revenue Agency could challenge the dividends as not being reasonable, given that parents make no ongoing contribution to the farming corporation and their capital contribution upon startup was nominal. And that will significantly impact Jim and Rita's after-tax retirement income. And it may impact the capital gains exemption on the transfer because it may fall now under the new passive asset definition. There are other concerns with the tax and split income rules. The arrangements were based on specific Income Tax Act rules and interpretations that have been in place for many years. They are not tax loopholes. These rules can ignore the contribution of the non-active spouse in the operation of a small business and creates implicit gender bias. Rules will apply to current arrangements and creates significant compliance costs and tax uncertainty in terms of the reasonableness test. And we have the triggering of gains to avoid the application of the lifetime capital gains exemption, which will create additional tax and legal costs next year. The rules can also apply in circumstances that create inherent unfairness in retirement, as the example I gave with Jim and Rita, or death or illness. Is there partial relief in sight? Well, the Prime Minister made an announcement on October 17, 2017, stating that the government would be moving forward with the new income sprinkling rules effective in January 2018. But there will be simple, clear rules restricting the income payouts to active shareholders and employees. What those rules are and how clear they would be determined at a future point in time. And there would be potential breaks for family business succession. The question, of course, would it be just for farming and fishing, or would it apply to all small businesses? And what about access to lifetime capital gains exemption by all shareholders in a family business? It appeared that we were looking at tax reform by press release, a quotation I took from Florence Marino, who made that statement at Navigus Professional Development Day a couple of days later. In the proposed updates, which address income sprinkling, adults, now think children and spouses, common law partners, or the primary shareholder, the driver of the business, will be asked to demonstrate their respective contribution to the business based on the following factors. 1, their contributions of labor. 2, their capital or equity contributions. 3, the financial risks of the business, like co-signing a loan or other debt. Or 4, past contributions in respect of labor, capital, risks. Potentially a combination of those 4 factors. The government signaled that it would be releasing more details on this in mid-December of 2017. Well, they did just that on December 13th of this month, and it would be effective for 2018 tax year and onwards. The Canada Revenue Agency also issued guidance on the application of the split income rules for adults, plus included a short Q&A or question and answer document. The rules are simpler, clearer, and more targeted, including bright line tests. And there are going to be some automatic exclusions for certain family members regarding the tax and split income at the highest marginal tax rates. The new rules will not apply to compound income earned by family members under the age of 25. Specifically, income earned from the investment of income that is subject to the income sprinkling rules would not be caught under these high or highest marginal tax rates. Well, what isn't going to be included now? The business owner spouse, provided the owner meaningfully contributed to the business and is age 65 or over. Now, that aligns with current pension income splitting rules and takes into account the fact that a business owner can play a significant role in providing retirement income for the owner. This may serve to address the concerns raised under the case study I covered dealing with Jim and Rita, who owned a farm corporation. Adults aged 18 plus who have made a regular substantial labor contribution, generally measured as being an average of a minimum of 20 hours per week, to the business during the year or during any 5 previous years. That recognizes that post-secondary students in particular may step back from the business during the school year. The labor contribution factor for the reasonableness test will have hours prorated for seasonal businesses like farming and fishing, and the 5-year period need not be consecutive. Also, not subject to the tax and split income rules would be adults aged 25 and over who own 10% or more of a corporation that earns less than 90% of its income from services and isn't a professional corporation. That's consistent with current tax rules concerning capital and recognizes that some service-based or professional-based businesses often do require significant capital to do business. Service or professional-based businesses need to pass the labor test I just mentioned, and shares held in a trust for the benefit of an individual will not be considered excluded shares. Again, this may address some concerns shared under the Bill and Janice study. Also, not subject to the tax and split income rules will be people who receive capital gains from qualified small business corporation shares, qualified farm or fishing property, if they wouldn't be subject to the highest marginal tax rate on the gains under existing rules, and that preserves the lifetime capital gains exemption. This may address at least some of the concerns covered in the case study featuring Bill and Janice. Family members aged 25 or over who don't meet any of these exclusions will be subject to the reasonableness test to determine how much income, if any, will be subject to the highest marginal tax rate. In certain cases, adults aged 18 to 24 who have contributed to a family business with their own capital will be able to use the reasonableness test on the related income. Taxpayer clients will have a year to get compliant. That means non-service businesses, for example, have a full year to get on side with the 10% ownership test, and service businesses can take that time to adjust to that exclusion. The Canada Revenue Agency has released guidance for these measures that you can find on the website. There are also a number of concerns with passive investment and the passive investment income rules. Business owners often retain and invest surplus funds to cushion against business cycles, provide security for better financing terms, and future acquisitions and expansion. The new passive investment rules, as they were proposed in July of 2017, could significantly impact the ability to cost-effectively manage cash flow requirements of the business if these funds must be withdrawn to avoid more onerous tax consequences. Deferred taxation methods can result in combined corporate and personal tax rates on passive income in the range of 70% or more of that income. And there will be additional complexity and cost in administering pooling rules. Retained corporate surplus is often used for retirement planning purposes, compensating for reduced retirement savings plan contributions and providing equity in relation to members of pension plans. The new anti-avoidance rule in Section 246.1 permitted the recharacterization of an amount received by a corporation, example capital dividends, to be a taxable dividend where there is a disposition of property as part of the series, and one of the purposes of the series of transactions is to effect a significant reduction or disappearance of assets such that tax is avoided. That new Section 246.1 of the Income Tax Act of Canada may also be used to reduce any capital dividend account arising from the series of transactions. And finance is seeking input on the rules that will exempt genuine intergenerational transfers of shares to the corporation of an adult child. That begs the question, could the corporate legacy builder and corporate insured annuity strategies be challenged? The short answer is a highly cautionary and qualified one. These two strategies rely on the revised rules affecting corporate-owned life insurance and the credit of the capital dividend account. If you recall, those rules took effect in January of 2017 after some 5 years of negotiation between the industry and the Department of Finance. The Conference of Advanced Life Underwriting, or CALU, has sought specific exemption from any proposed rules on credits to the capital dividend account by life insurance proceeds. That said, we strongly caution you against the broad, public, and promotional use of these two strategies and others that minimize the dominant need for life insurance and stress the investment nature of implementing these strategies. Yes, life insurance may be far more advantageous in multiplying the benefits of dollars used to provide legacies and asset replacement. If it is used dominantly as an alternative investment vehicle, it could be subject to new or expanded rules that would seriously and negatively impact its benefits. It is an asset class, one that should be positioned with these things in mind. The good news is the Department of Finance is not pursuing its surplus stripping proposals for the time being. But let's look at those surplus stripping rules and the concerns. The rules will impact amounts received or receivable after some to-be-determined date and may apply to transactions that were started before that date, which is originally July 18, 2017. The rules introduced significant risk of double taxation on the death of a shareholder and the winding up of a corporation by the deceased estate. And Section 246.1 of the Income Tax Act of Canada gave significant discretion to the Canada Revenue Agency to challenge common and well-accepted planning strategies undertaken to avoid double taxation. There was no firm commitment to provide an exception for the intergenerational business transfers while simultaneously expanding the scope of Section 84.1 significantly, thereby encouraging the sale of family business to arm's-length parties, which in itself is a factual test. Now, statements have recently been made indicating an easing of this position and perhaps some backtracking by the Department of Finance, easing the concerns of those people dealing with intergenerational transfers of business. The Department of Finance stated they would not be pursuing the surplus stripping rules on October 19th. The proposed expansion of 84.1 and introduction of Section 246.1, the new anti-avoidance rule, both of the Income Tax of Canada, would not be proceeding at this time, or that's the way it was positioned on October 19th. And that addresses a number of major concerns arising from the consultation paper, including the ability of private corporations to pay non-taxable capital dividends to shareholders, the double tax situation for individuals who hold private company shares on death, and additional tax on transfers of family businesses to succeeding generations. At the Canadian Tax Foundation Conference on September 26, 2017, in the APF conference on October 6, 2017, Finance did posture some of the proposals as having unintended consequences and that they will listen, dealing with issues like the pipeline planning strategies and catching capital dividend account credits from any source, and won't be introduced for normal business decisions, and there will be no changes to another section of the Income Tax Act, Section 89. Now, this announcement appears to allow the continued use of certain planning strategies like pipeline planning, which are designed to eliminate double taxation on the death of a shareholder, something I'll go into a little bit deeper in a few minutes. It appears now that the original proposals on capital gains exemption and that Section 246.1 are now off the table. And that backstepping eases concerns relating to the possible application of that section of the Income Tax Act to corporate-owned life insurance. Now, these qualifying statements do create additional uncertainty in terms of implementing tax and estate planning strategies for small business owners based on current legislation. We may need to brace ourselves for a much higher capital gains inclusion rate, perhaps going back up to 75% from the current 50%. So watch for leaks of proposals in the 2018 federal budget. But what about an exception to Section 84.1 of the Income Tax of Canada? The government did not make any announcement relating to an exception to current Section 84.1 that would permit the intergenerational transfer of shares in order to create a level tax playing field with arm's length share transfers, and presumably this will be part of their ongoing consultation process. So we will continue to work with government to support the development of appropriate criteria that will permit shared transfers to certain family members or their corporations on a tax-neutral basis. That said, again, a government-issued backgrounder stated the Department of Finance will not be moving forward with proposals that would limit access to the capital gains exemption, certainly not at this time. Now, when a taxpayer owns shares of a private corporation, he or she is deemed to have sold those shares upon death, resulting in a capital gain. If the beneficiaries of the estate then wish to draw assets from the company, the estate accrues a dividend on that money. Without further planning, this process would result in paying double tax, once on the final tax return and again on the estate's dividends. Up until July 2017, there used to be two well-used strategies designed to address double taxation when a shareholder of a private corporation passed away. Let's review each one of these and then consider the issues with the new proposals. Let's consider the death of a shareholder and the loss carryback strategy. A shareholder is deemed to have sold his or her shares on death for fair market value. The estate then liquidates the corporate assets and starts a wind-up of the company. The distributions to the heirs would be considered a taxable dividend, but that would generate a capital loss in the estate on the disposal of the assets. And the estate may carry back a capital loss to the deceased's final tax year under subsection 164.6 of the Income Tax Act of Canada, as long as the wind-up occurs within 1 year of death. The capital loss would offset that deemed capital gain realized on death, and the result would be it leaves a higher dividend tax but no capital gains tax in that situation. It is commonly called the redemption and loss carryback strategy. Another alternative is the pipeline strategy, which is also designed to avoid double taxation. In this strategy, the estate sets up a new company, NewCo. Shares from the existing company are transferred to the new company. The estate receives a note for the value of the transferred shares plus a share capital in the new company. There's no capital gain. The cost base of the shares are increased by the capital gain realized on death, and any increase in share value since death may be deferred until a joint election by the estate and the new company under Section 85.1 of the Income Tax Act of Canada. The estate owns NewCo shares, which own the existing company shares. Now, if that structure is maintained for 1 year and the existing company is continued to operate, not just hold cash, then a number of things can happen. The two companies could amalgamate after that period of time and then wind up the company. They could liquidate the corporate assets. The cash would pay off the note to the estate on a tax-free basis. If that waiting period is not followed, the strategy would be disallowed. Now, there's been lots of Canada Revenue Agency correspondence on business assets, and of course, as included in that would be the fact that an investment portfolio would not be considered business assets. But the result of this particular strategy is that there would be no dividend tax, only the lower original capital gains tax. Now, pipeline planning has been used not just for post-mortem planning, but also for inter vivos planning. It's the latter that may have caused the greatest concern for finance. So on a go-forward basis, post-mortem planning may be okay. Otherwise, the share redemption strategy with loss carryback may be the only option to avoid double taxation. The challenge with that is that you need to recognize those capital gains and losses within 1 year of death. And if the capital gains are recharacterized as dividends, then this strategy won't work either. So that becomes problematic for business owners who sold their corporate assets and left cash in the company to fund retirement. Let's look at an example. Helen is divorced with 2 teenage children. She starts up an internet-based company with nominal capital contributions. She sells those assets of the company for $1.5 million. And after the company pays tax, approximately $1 million is left in her company to reinvest in new businesses. And Helen is trying to decide what she wants to do next. She certainly is too young to retire. She has 2 young girls. And there's all kinds of things she still wants to do. But she leaves that money in the company for new business ventures. Unfortunately, Helen dies in a car accident, and her executor plans to enter into a pipeline strategy resulting in total taxes of approximately $265,000, because this whole operation is going to take more than a year. The estate settlement and strategy implementation takes over 1 year. But the new proposals would not have allowed for pipeline planning, and the executor cannot use subsection 164.6, the loss and carryback redemption strategy, since 1 year has now passed since Helen's death. What is the outcome of that? Well, first off, the pipeline strategy would have generated taxes of $265,000, leaving the minor children with $735,000. The net corporate value was $1 million. Now recall that the taxes on the proceeds of the asset sale that Helen was alive was $500,000. That company had been worth $1.5 million after paying taxes, now $1 million. So the government has already received $500,000 in income taxes. Total taxes generated, $765,000. The new proposals will result in the following. The combined tax bill on death and the corporate windup would now be $735,000 instead of $265,000. Again, that is on top of the tax on the sale of the assets, which would be $500,000, meaning that the total taxes through the series of transactions would now be $1,235,000, leaving the two minor girls with $265,000. So if a business that was valued at $1.5 million, the two minor children would receive $265,000. It seems that these proposals would have flipped around what the taxes would be to the Canada Revenue Agency versus what the children would get. $265,000 and $735,000 now reversed, as you can see. Well, how does this math actually look? Well, under the old legislation, or the current legislation, the total taxes would have meant that the minor children would have received 49% of the value of the company, and the government would receive 51% of that value in taxes. Under the new strategy as proposed, the minor children would now receive less than 18% of the value of the company, 17.7% of the company. The total taxes generated would have been 51% under the old strategy. Under the new strategy, of course, a whopping 82.3% in taxes would have been generated through this series of transactions. I don't know how anyone could have thought that that would have been a fair outcome in this type of a scenario. Let's now consider what you could do. And one of the things you could do, of course, is buy life insurance to make up for that massive drop in the value of the company so that the children would be provided with more money to be taken care of until they reach the age of majority and perhaps even help them through university, the things that Helen would have done had she been alive throughout. Let's look at corporate-owned life insurance and the concerns around that. Section 148 of the Income Tax Act of Canada has some basic rules and associated regulations on life insurance, and those should not change in terms of the death benefit being tax-free, in terms of allowing for the tax-exempt accumulation of money and the tax-free payout of those monies as long as it fell within the new tax-exempt rules and the existing rules with respect to dispositions. Distributions, of course, of taxable dividends to family members funded by life insurance may be affected by the proposed tax and split income rules because distributions of life insurance proceeds from policy dispositions may be caught by passive investment rules. You see, life insurance would be considered a passive asset. Again, a cautionary note. Actively promoting cash value life insurance as an answer to corporate passive investing could attract all kinds of unwanted attention by the Department of Finance and the Canada Revenue Agency. The proposed rules already are an issue with cash value payouts because those monies, if they were considered a passive asset, the income of which would also be passive, would then be ineligible for refundable tax. And all that would be needed would be a tweak to the current income tax rules to catch all of this under passive investments. The death benefit may not even be accredited to the capital dividend account, and of course we'd have some real issues now in terms of paying out monies to shareholders. Now under passive investment rules, gains on dispositions, the refundable tax dividend would be denied, so the top tax would be paid on the cash surrender value, and the distributions would be taxed as ineligible dividends. And once the adjusted cost base disappears, the tax percentage could top 70%. According to the Conference of Advanced Life Underwriting and others, the theory behind the tax treatment of passive income could be applied to life insurance, a passive asset, via further restrictions to the capital dividend account. We need to stay focused on the life insurance need as a driver for the strategy. We need to be prepared to defend why the structure is set up that way in terms of the ownership, who the life insured is, who the beneficiary needs to be, who is the payer, what type of insurance is actually being used. Let's look at the loss of integration on the taxable dispositions of life insurance. Specifically in this particular table, I want you to draw your attention to the last two columns, year 30 and year 40. Under the passive investment rules, the gain on disposition, the refundable dividend tax would be denied, so the top tax would be payable on that cash surrender value, and distributions would be taxed as ineligible dividends. And once the adjusted cost base disappears, the tax could be upwards of 70%. If you look at that particular chart, you'll notice that in year 30, the cash surrender value would have been $406,000. The adjusted cost base at that point in time would be $216,000 in this particular illustration. The policy gain, which would be the cash surrender value over the adjusted cost base, would be $190,000. That would trigger taxes at over 50% of $96,000. The tax paid by the shareholder would be an additional 42% or $130,000, leaving after-tax funds of $180,000, specifically $179,818 out of that $406,000. The tax as a percentage of income would top 55.71%. If we just move one more column to the right and look at year 40, the cash surrender value would be $620,000. The adjusted cost base would now have been reduced to $59,000. The policy gain would be $561,000. The tax paid by the corporation, $282,000. The tax paid by the shareholder, $142,000. After-tax funds then available to the shareholders would be $196,000, representing total taxes of 68%. Now, the Canada Revenue Agency could reassess and treat that taxable dividend with accompanying denial of refundable tax paid by the corporation on the original monies and then used to fund the policy. But that now appears to be off the table for the revised proposals. Good news. Good news for that, and perhaps good news for the pipeline strategy, which would also be impacted by that, because with that, as I'll show you another example, pipeline strategy, according to the new proposals, would trigger the same type of result as if there had been no planning done at all. So let's look at that. Let's look at a corporate owned life insurance policy, single owner, owning common shares, where the corporation owns $1 million. They've got a GIC, there's no ACB, there's no paid up capital. With no planning at all, the fair market value of those shares would be $1 million. There would be tax on death, the capital gain of $265,000. There'd also be a tax to dividend of $450,000. There's that double taxation. Net funds to the estate would be $285,000. That would represent 71.5% tax on the wind-up and sale of that company. If you looked at the two strategies that we talked about earlier to reduce the taxability, reduce that double tax, if we use the redemption and loss carryback strategy with no insurance, the fair market value again would be $1 million. We wouldn't have a capital gain to worry about. We'd still pay the tax on the dividends of $450,000. The net funds to the estate would be $550,000, and that would represent total taxes as a percentage of the value of that business of $1 million of 45%. If we move over to pipeline planning and look at the fair market value of those shares with no insurance, again, that company would be worth $1 million. We would need to pay the tax on death of the capital gains. We would avoid paying tax on dividends as well, on the redemption. The net funds to the estate in that situation would be $735,000, and the total tax as a percentage of the value would be 26.5%. So you can see why pipeline planning would be that much more attractive than certainly doing nothing, but even more attractive than redemption and loss carryback. The fact of the matter is even if you wanted to redeem and carry back the losses, in many situations it was difficult to do that in 1 year, and you need to do the redemption loss carryback within a year to take care of that strategy. If, of course, you did it and it took more than a year and pipeline strategy was denied, you'd then be in a very, very different boat. So under the proposed rules, everything looks exactly the same. If you had done no planning, you'd end up paying taxes at 71.5%. With the new rules, you would still have the redemption and loss carryback strategy available to you, which would result in taxes of 45%, leaving net funds to the estate of $550,000. However, with pipeline strategy gone, whether you engaged in the pipeline strategy at all or did not, the tax would be exactly the same, 71.5%. So under the current rules, qualified eligible small business income is taxed at the low rate, about 15%. But you need to satisfy the rules to maintain that status. It includes, the rules include an amount of passive investments that are not used in active business. It includes rules around realized income on invested retained earnings that are taxed at the top marginal tax rates. There would be no dividend gross up or tax credit for dividends received by the corporations. We're looking at Part 4 tax, which would equal 38.67%, which may be payable on dividends received and would include a 10.67% refundable tax, which may be recouped when taxable dividends then are paid out to shareholders. Now, the federal government announcement on October 17, 2017, reduced federal taxes on Canadian-controlled private corporations from 10.5% to 10% effective January 1st, 2018, and then we'll drop them again to 9% effective January 1st, 2019. What does all this mean? Well, it seems that there's partial relief in sight. The Finance Minister made an announcement on October 18, 2017, revising the passive income rule to only target what the Finance Minister said was 3% of small businesses. Where they came up with that number, no one's quite sure. The change would also be not retroactive. Not retroactive. So that means these new rules would not affect existing savings nor income on those savings. The issue is, what would be the grandfathering date? It's guessed right now, since there's been no announcement now, and that's now mid-December, that that may form part of the 2018 federal budget. The existing rules would apply now to passive investment income earned from not only existing savings and income on those savings, but those existing rules would also apply to passive investment income earned on new savings, as long as the new savings were less than or equal to $50,000. That would be about $100,000 in capital gain. And the estimate is that if you're earning about 5% on a nominal rate of return on your investment income, you could probably afford to save about an additional $1 million in savings, the income from which would not be subject to the new rules. However, the excess will be subject to the original punitive rules released in July 17th. Now, when is that going to be introduced? How are we going to track it? How are we going to set it on the books? Again, those details are yet to come. We expect to see them in the 2018 federal budget. Let's look at investing retained earnings and comparing the current rules to the new rules. The theory of integration is that the total tax paid should be approximately the same as if there was no corporation. But the new federal tax proposals severely restrict and or effectively eliminate refundable tax and make it harder to access accumulated refundable tax, making that in essence a permanent tax. They also may treat taxable dividends funded by cash in the corporate-owned life insurance policy, again in a passive asset, as being ineligible for refundable tax, and then that money would be taxed at the maximum rates. What are the implications for corporate investments? There may be no capital dividend account credit for the untaxed portion of capital gains in corporately held investments. It may be tax-free to the corporation, but will be taxed as a taxable dividend or salary to shareholders. And again, watch payments to inactive shareholders, because those incomes could be taxed at the top rates. And reinvested payments originally could also attract top rates. That, of course, now has been withdrawn. If the primary shareholder, a parent, is taxed at the top rates, why bother with income sprinkling? Because the new rules would have taxed that income going to somebody else also at the top rates. If all that income is being taxed and taken in personally, and you're below the top tax rates, why would you bother with income sprinkling or splitting? And there's no refundable tax, there would be double tax. So why bother? The idea here is to shut down any type of income sprinkling with the new tax and split income rules. Changes were made, announced by the government, impacting the tax on dividends, effective January 2018 and 2019. These are concurrent with the two new reductions I just announced to small businesses and the tax rates on those. A notice of Ways and Means motion was implemented to effect these changes. We expect that to go through as is. And what will happen is that there will be adjustments made to the dividend gross-up and tax credit mechanism, resulting really in an increased amount of tax payable on non-eligible dividends paid in 2018, 2019, and future years. All this came out as part of the fall 2017 economic statement released on October 24, 2017, which included changes to the small business tax rate, as I mentioned before. Let's look at that in detail. Non-eligible dividends are received by Canadian-controlled private corporations that pay income tax at the small business rate. They are grossed up and reported on the receiving individual shareholder's personal income tax return as part of total income. The individual then may claim a tax credit, and he or she may claim provincial dividend tax credits on that income. The Notice of Ways and Means motion, published on October 24th, will reduce the federal gross-up and tax credit rate for non-eligible dividends. And as you can see on the slide, currently, the gross-up is 17%, That will be reduced to 16% in 2018. The gross up will be reduced to 15% in 2019. The dividend tax credit, which currently stands at 10.5%, will be reduced to 10.03% in 2018, and the dividend tax credit will be reduced to 9.03% in 2019. The adjustments in the gross up and tax credit scheme for dividends paid by Canadian-controlled private corporations on income qualifying for the small business tax rate will increase the amount of income tax paid on this type of income and may offset any perceived advantage gained from the announced reductions in the small business tax rate to the shareholder. These income tax changes may be in addition to proposals affecting eligibility for refunds of the extra income tax levied against corporate passive investment income. Remember that corporate investment income is taxed at the general or high rates instead of the small business tax rate, and that's aimed to discourage shareholders from using their corporations as tax shelters for investment income. Part of that extra income tax may be refunded when the corporation declares a dividend to the shareholder. Otherwise, the total amount of income tax paid could approach 70% or more, much higher than if the individual had received all the profits from the company and invested them personally. Again, the income tax proposals put forth by the Department of Finance drive the total income taxes owed to these much higher levels. First, by denying any refunds and extra taxes first collected against the corporation, and second, by adjusting the gross up and tax credit scheme. We do believe that one of the likely results of this initiative, whatever its final form, will be to rekindle an increased demand for plans with private companies with tax sheltering features. One of those plans could be individual pension plans or IPPs. Now, what's the motivation to establish an individual pension plan? Well, you can increase retirement savings on a very tax-friendly basis. You've got the ability to reduce taxable income in the business through past service contributions. This gives you the opportunity to retain key employees, strip excess cash from the company in preparation of the sale or wind-up of the company. These plans could form part of a living buyout, particularly by employees who may not have ready cash to buy out a business, and the selling shareholder says, I don't need the money right away. And it can address the proposed federal rules impacting Canadian-controlled private corporations. What is an individual pension plan? It's a one-person registered defined benefit pension plan sponsored by an employer where contribution amounts are determined actuarially. It really is a supersized registered retirement savings plan that requires special actuarial administrative services for compliance purposes. The benefits can supply an annual pension to that shareholder or a key employee equal to 2% of indexed T4 earnings, subject to the maximum pension limit, and the benefits would be adjusted for inflation based on the Consumer Price Index. Who would be your candidates? You'd be looking at an incorporated company that pays T4 income to an employee. Dividend income or T5 income would not be pension eligible. Typically, you're looking at people who are over the age of 40, the older the better. Most individual pension plans are implemented between the ages of 50 and 60, and you can maximize T4 income at $146,000 to optimize how much money you can put into an individual pension plan. If you're going to pay out more money than that, you could pay the balance out as dividends. Your prime candidates would be a profitable business seeking additional retirement savings opportunities, incorporated professionals, business owners, and highly paid executives. There must be that bona fide employment relationship, and so they can have compensation that's eligible for pension purposes, which includes things like salaries, wages, bonuses, and director's fees, taxable benefits and allowances, but self-employed earnings would not be pension eligible, and of course, as I said earlier, the dividend income would also not be eligible for pensions. And it's dividend income that's under attack with these federal proposals that were released in July 17, and now with these new Ways and Means tax measures scheduled to take effect in January of 2018. There are a number of advantages that an individual pension plan can have over a registered retirement savings plan if you're going to leave money inside the company. Higher contribution amounts for people fitting the age and earnings profile, significant past service contributions to the implementation. There's the opportunity for creditor protection. Interest on funds borrowed for contributions to an individual pension plan would be tax deductible. Not so with the registered retirement savings plans. And contributions can be made within 120 days after the corporate year end, as opposed to 60 days after the calendar year end for a registered retirement savings plan. Someone aged 55 years old with full past service back to January 1st of 1991 and maximum earnings could expect to accumulate more than 50% additional savings using an individual pension plan when compared to a registered retirement savings plan at ages 60, 65, or 71. Now, past service provided must satisfy a past service pension adjustment, and for past service, connected persons, those are shareholders that own more than 10%, can only go back as far as 1991. But non-connected employees can go back as far as their date of hire. Now, that's for money that stays in the pension plan, and assuming that's what shareholders have been doing, keeping the pension plan, individual pension plan makes sense. But there's a lot of math that supports the notion that if you actually paid money earned in the company out to a shareholder and put that money into retirement savings plans and excesses in the tax-free savings account, you could be as well off or better off than leaving that money in the corporation. So the individual pension plan makes a great alternative if you're leaving money in the corporation or you've got excess funds here that could be caught by the new rules. Now, another benefit of individual pension plans is they can be set up on a multi-generational basis. Ideal for family businesses where there's an opportunity or an interest in passing on that business down to a succeeding generation. You see, there's no need to wind up a plan on retirement. Future generations can join an existing plan if they're employed by that sponsoring company, and the death benefit after the survivor of the first generation retires leaves assets in the plan to fund the children's pension benefit somewhere down the road. Caveats: these are real pensions, so they're going to be subject to provincial pension acts, and they need to be compliant. There are new monetary penalty provisions that are effective January 1st, 2018 for noncompliance in the province of Ontario. Regulation 909 of the Pension Benefits Act of Ontario has 109 schedule provisions, and British Columbia has some similar authority. If you do things wrong, you're non-compliant, an assessment can be made against the individual, the corporation, and others, including trustees. The pension fund cannot pay penalties if you're in violation of these regulations, so this may be a good reason to retain professional firms to set up and administer these individual pension plans, including acting as trustees, rather than try and do it on a do-it-yourself basis, because these penalties and the provisions are so onerous and so severe. There is a Taxpayer Bill of Rights. According to the Government of Canada website, the Taxpayer Bill of Rights describes and defines 16 rights and builds upon the Canada Revenue Agency's corporate values of professionalism, respect, integrity, and cooperation. The Taxpayer Bill of Rights also sets out the Canada Revenue Agency's commitment to small business to ensure their interactions with the Canada Revenue Agency are conducted as efficiently and effectively as possible. In addition to the 16 rights that applies to all taxpayers, the Taxpayer Bill of Rights also has a 5-part commitment to small business. The 5 commitments made to small business acknowledge their importance as the engine of growth in the Canadian economy. These commitments also complement the government's pledge to create a competitive, dynamic business environment in which Canadian businesses will thrive. They recognize the role the Canada Revenue Agency can play in minimizing the compliance burden, specifically the amount of paperwork employed and involved in complying with the tax system. Now, the federal proposals, as they were released on July 17th, and even with a lot of the announcements and updates and retractions made since then, still appear to be very much at odds with these Taxpayer Bill of Rights. Now, challenges bring opportunities. If shareholders can no longer sprinkle income, they may retain the income, potentially leading to a larger future capital gains tax burden. So explore the use of life insurance if the capital gain is to be triggered at death. Shareholders may withdraw future corporate surplus not needed for active business endeavors and invest those monies personally. Mathematically, as I said earlier, it does make sense to optimize raised retirement savings plans and tax-free savings accounts to grow assets personally rather than grow them passively in the company. Other options, as I said, include individual pension plans, prescribed loan rates, and repaying shareholder loans. Opportunities are available with all the challenges being presented. It means the opportunity to meet with clients and other professionals, to demonstrate your value proposition and revisit some of the strategies that you've already set up and revisit some of the strategies that may be available under these revised proposals. Will some strategies still be used? Incorporation? Yes. People running a business will still incorporate. They want to protect themselves against liabilities. They want to avoid personal risk. Free strategies will still also be applicable to protect the value to the date of the original shareholders. If the owner is active post-freeze, everything's going to be okay. If a family trust is used, again, put active people in the trust. And that way, you offer some protection under family law and from creditors. Challenges bring more opportunities. On a life insurance perspective, again, deal with the higher taxes at death, which all these proposals will generate. Life insurance can help preserve the corporate asset value for beneficiaries. They can pay for capital gains that are ineligible for the lifetime exemption. It can help fund a wind-up of a business. It can fund the sale of a business. And certainly life insurance can replace funds used for survivor benefits now and now lost to taxes. It can also support the insured retirement plan strategy. On the investment side, insurance-based investments really in many ways are in the same boat as others. So promote the distinguishing features and benefits of an insurance-based investment and use surplus and profits to fund individual pension plans, retirement compensation arrangements, and other group benefits. That concludes my presentation. I now turn it back to Adrian.
Thank you, Peter, for another interesting and informative webinar. Just a reminder to our attendees that you will receive CE credits within 2 to 4 weeks. An email will be sent out shortly with a replay as well. And should you wish to complete previous webinars, you can do so at empire.ca in the TRIIPSS section. Thank you.